Hello and welcome back to the Data Privacy Lawyer. Today's review is going to be on some terms of service being offered by an AI organization. I'm just going to quickly take a look at their solutions. So it's an AI note taker and meeting partner that captures what matters, connecting you with your favorite tools and scaling with your team. Okay, so essentially it takes notes. Let's go back to the terms. So these were last updated August 11, 2025, and they've identified the name of their legal entity, which I talked about being really important. It's also really important to indicate the date that your terms of service was last updated. And the reason this is important is because the terms of service associated with a solution, they work hand in hand. Let's say, for example, the solution for sales and marketing has changed, right, since this day. Let's say in December, there is a launch associated with the AI note taker that influences how it processes personal data. In that case, an organization should update its terms of service to reflect that change because it influences how a consumer interacts with the solution. That's why this date is so important. If your new solution or AI note taker, for example, has updated maybe its third parties or service providers, and there is a manner in which the processing of personal data has changed, that generally will influence how customer interacts with the solution. It's really important to be transparent about that, even within your terms. So we can see here, by clicking sign in, etc., you agree to be bound by the following terms and conditions, including Fathom's privacy policy. Now, I think something that would be valuable is to have the link in here so that you can click it directly and be able to read the privacy policy alongside the terms of service. But which privacy policy are they referring to? The reason I think it's valuable to highlight this is some businesses have different privacy policies depending on their website URL. It may be, and this is why having a privacy counsel is so valuable. Sometimes these products are offered in different geographies. So what happens is sometimes companies will buy different URLs for each legal entity that they have in different countries because the solution is different in each country. That's something that a customer may not know. Writing that you're putting the privacy policy here without putting the link doesn't help the customer to identify what your privacy practices are that you're referring to for the terms. Adding the link makes it clear, particularly if you have the solution and different URLs, which a lot of companies do. I've actually done a review on my channel, and it was basically for a car company, and the car company operated in the European Union, and the cookie notice that was displayed on the European website was not displayed on the US website. And that's why it's really important to put the links if you're going to be placing your terms on your site. The service provides tools for use in connection with the conferencing service provided by Zoom, Google Meet, Microsoft Teams, and other compatible third-party conferencing applications. Now, the reason I've highlighted this sentence is because we already know that Zoom, Google Meet, and Microsoft Teams all process voice recordings, and some of them, all of these, your face is displayed too. Now, we already know that the definition of personal data is any information that identifies an individual. So essentially, what Fathom is saying here is there is a relationship between them and these other platforms that process personal data. And that needs to be taken into consideration depending on whether or not there is further processing by this entity. Now, we'll continue to read these sections, but I really want us to focus on the privacy piece and how important it is to have your privacy counsel review your terms of service, because although it's not traditionally a privacy document like the data processing agreement or the privacy notice or a cookie notice, there are provisions that are going to overlap, and we can see that here already. If you're agreeing to be bound by this privacy policy, surely you should know what the privacy policy states, and that's listed in your terms. So outside of any documentation that you're going to agree to, you should transfer to your privacy counsel to see and make sure that there is a consistency amongst all of the documents, even if they're not traditionally a privacy document. See Fathom video for more details on how the service works. This is something I would review. If I was their counsel, I would be reviewing this. This is going to influence the other provisions that exist within these terms. I would review this. We have multiple tiers of subscriptions, etc. Team account. A team account means any enterprise account you hold with Fathom under the name Team Business or Team Edition. The service is owned and operated by Fathom. The visual interfaces, graphics, design, etc. data, including source code or object code, product, software, services, and all other elements of the service provided by us are protected by intellectual property and other laws. I'm intrigued about what constitutes data. This is something I would query if I was their counsel. what type of data are you inferring here? Because surely the data that is uploaded by a customer belongs to the customer. But this is something that I would query. Is this personal data, or what data you're alluding to here? This is also why I think it's very valuable to have definitions in your terms, because it's going to give more insight. Outside of this definition, Teams account, I don't see any other definitions for some of the terminology. I think it would be valuable to clarify what constitutes data here, because they're saying that they own the data provided by them. Is this the personal data? What type of data does this constitute? That's really important. Your content, you may be able to record or transmit content using the service, including content that is accessible by or visible to third parties, such as other users of the service. Now, this indicates to me that there is going to be some type of personal data. We can see here it includes messages, images, text, audio content, including voice and sound recordings, both of which are personal data. Comments, photos, which could include personal data, and video. And the reason I make this review and looked at the solutions was it gave me insight into what may be uploaded into this solution. Now, there's a terminology in the data protection space. It's called data minimization. Essentially, you should only process the data minimally necessary for the purpose of processing, essentially. And what that means in simpler terms is whatever your solution provides, only data minimally required to provide the service should be processed. This list should not be including things like healthcare data, because that's not the purpose for the solution. The solution is an AI note taker. Now, I don't know what type of notes are going to be taken. It may be that healthcare data is included in that, let's say, for example, in the messages, but that's also a risk that the organization needs to review internally. And it may be that if it is provided to customers that take notes related to health, then they're going to need to re-review their terms and service to make sure they comply with all the applicable data protection laws when it comes to processing that type of information. So there's a lot of questions that I have in my mind about some of these provisions, which is another reason why it's so important to update the time that your terms were last updated. Let's say, for example, there's a lot of interest in the Fathom tool by healthcare providers. Essentially, what Fathom is saying is if they take on these healthcare providers and there are notes taken related to PHI or health information, how is Fathom going to handle its responsibilities when it processes that type of information? These are all business decisions that should be reviewed by a privacy lawyer. We may use, reproduce, and format your proper display, your user content only as necessary for us to provide you the service, and we will distribute your user content to your users and third parties as you may select. This is interesting. I think that for me to make an opinion on this sentence, I would need more insight into the actual solution. Again, this sentence would be something that I would query, because who are the third parties that a user could select to share their information with? Is it those that are listed above here, like Zoom? I think there's a lot of intricate details that are not being displayed in the terms that customers are not privy to, but a privacy counsel definitely should be. And whenever I look at these terms, I always look at the provisions related to privacy. There's going to be other influences on legislation, like intellectual property. We saw that. And I think one of the things that's very unique about artificial intelligence is its overlap with lots of different laws outside of the data protection ones. But because that's what we do at the firm, that's the review that we're going to get on this channel. So I hope you enjoyed this simple review. If you have any comments or questions about any of the opinions that I have, leave a comment below and I'll see you in another one.